Good morning and welcome. This is the second meeting and the first public hearing of the Special Select Committee of the Senate on the Evidence Amendment Bill 2019. This meeting will be broadcast on Parliament Channel 11, Parliament Radio 105.5, and the Parliament's YouTube channel, ParlView. My name is Clarence Rambarat. I'm the chairman of this Special Select Committee. I would now invite my other colleagues on the committee to introduce themselves, starting on my right.
Good morning again, Nigel De Freitas, member.
Good morning, Anthony Vera, member.
Good morning, Saddam Hussein, member.
I think they heard me.
Thank you very much. We are also supported by the secretariat provided by the Parliament, Mr. Greenwich and Mr. Lucio, and by the team from the CPC's office, who would be here with us and throughout assist us in some of the details of the bill. We have before us today the representatives from the Trinidad and Tobago Police Service, led by DCP Crime and Support, Mr. Harold Phillip. Mr. Phillip, welcome. Welcome to you and your team. And I'd now ask your team to introduce themselves.
Thanks, Chairman. Good morning, everyone. I am Harold Phillip, Acting Deputy Commissioner of Police, Crime and Support. On my left, I have Acting Senior Superintendent Prague of the Court and Process Branch. And on my right, I have Acting Superintendent Francis of the Special Investigation Unit.
Thank you very much. This bill was laid in the Senate, and the bill was laid in the Senate. No, I said this bill. Maybe because I'm from Rio Claro, it sounded like Bill. This bill was laid in the Senate, and after several members made their contributions, the Senate took a decision to submit it to this Special Select Committee for further considerations on not on the policy or the merits of the bill, but the actual contents of the bill. The bill seeks to introduce some measures which are new to our jurisdiction, and no doubt brings a lot of debate in the Senate and out in the public, and maybe amongst those persons who have to enforce the provisions and those persons who have to prosecute, and certainly among those persons who have to defend clients in the future. So it is new in some areas, and in some areas we recognize the Attorney General is seeking to make improvements to existing procedures. The committee has itself already had some discussions on the bill in terms of the approach. And one of the areas, not only for the committee, but I'm sure for the public, one issue that has been generating a lot of interest in the public is this issue of CCTV and video recordings, and how it is currently used, how they are currently used, and what is proposed in the bill in relation to video recordings on the whole. And we recognize that in different sections of the bill, the issue of video recordings arise. So I want to invite Member Vera, the independent senator represented on this committee, to open the discussions on behalf of the committee, specifically on the broad issue of video recordings and CCTV in the current context of criminal law enforcement in the country. Member Vera.
Thank you, Chair. Clause 12A(I) of the bill provides that a video recording recorded by means of a closed-circuit television camera shall be admissible as evidence. Now, We have some questions about what does that actually contemplate? Is it all CCTV cameras? Is it CCTV cameras that are used by the police and approved by the police? How will that impact the things like mobile phone devices? If you could elaborate on that first, we'd be glad.
Well, in this particular, our understanding with respect to AI, 12 AI, it speaks to closed circuit TV camera, video recording for closed circuit TV camera. Well, our understanding is that whether it be the public CCTV camera or private CCTV television cameras, this is what it speaks to. But you did make mention with respect to video recording on phones. I gather that that too may also be captured under the Evidence Act with respect to video recording generally.
So your understanding is that, so for example, when you look at Ian Allen's show and he's showing you CCTV from a restaurant or a bar, that would be admissible under this section?
Yes, because at present we do use video recording either from the public or what we obtain from private residents.
Member Hussain?
Thank you. So is it this current state of the law is that video footage can be admitted and is admissible in a court of law?
Yes.
All right. And what is the policy of the TTPS when it comes to gathering video footage? And this has been a concern from members of the public, that I have a camera system at my home and a crime takes place and the cameras were able to capture the footage. The person refuses to give over the footage to the TTPS. What is the avenues available to the police service with respect to gathering the relevant footage from these private residences? And I say this because we have to operationalize the legislation. And from your answer before, you indicated that CCTV footage may contemplate footage in a private residence also. So what is the policy as it regards the police service in gathering that relevant footage?
Well, the normal practice is that when we go to obtain video footage or assistance from private residents, we make a request voluntarily, and if we get it voluntarily, under normal circumstances, that is okay. But if we do not get it voluntarily, we are also, because we are investigating a matter and we need to get evidence, we also contemplate using a search warrant.
I want to ask a question there. If that problem exists, is there a time frame? Like, for example, if I say no, and by the time you go to get a search warrant and so on, I could delete it or make some change to it. Do you have a time frame involved in that?
Well, we are required when investigating matters and searching and looking for evidence or gathering evidence to move with all urgency so that there's a possibility that a person could in fact delete it, but we, at the end of the day, we could only do our best in terms of entering the premises legally and lawfully by the means of a search warrant.
Thank you. What are some of the circumstances or instances or probably some of the obstacles that the police service and you could probably share your experience with the DPP's office also in terms of, because you gather the evidence at the end of the day. What are some of those obstacles that may in fact prohibit or hinder evidence by video means from being admissible in court?
there is always the issue as to who made the video. So we need to ensure that the video is an original, it was not interfered with, it wasn't Photoshop, and we need to, and it was not tampered with. So we need to, the person who is actually going to give that evidence and produce the video, who we're going to use to produce the video, we must have evidence that that person actually made the video and evidence that it wasn't tampered with.
And is there any way that the TTPS has in order to certify that the video that was captured was not interfered or tampered with?
Well, when we are conducting our investigations, we have officers who have been certified to retrieve video footage, and those are the officers who we usually send to retrieve our video footage. Where the video footage has been supplied by a private person, certainly we would interview that person generally to ensure that the person is credible and is speaking the truth. So at the end of the day, based on other corroborating evidence, sometimes they do have time, because it was taped, there are other sources that it may be backed up somewhere and so on. We look at all of that to ensure that it is an original.
Ms. DCP Philip, as you raise the issue of recordings and video recordings, and I just want to ask a question based on discussions that have emerged in the public domain. What is the TTPS doing to address this issue of footage from crime scenes, which, in looking at the footage, it has to be recorded by somebody who has authority to be on the crime scene, maybe some law enforcement person, and this footage finds its way on social media. Is that an issue in the police service? And if it is, how is the police service addressing the issue of the security of footage obtained by law enforcement officers and cases in which that footage is put into the public domain without authority?
The TTPS we are developing a social media policy to deal with aspects of officers who put unauthorized footage, on social media, as well as the TTPS. We have been using some moral suasion in the main to let officers understand the serious responsibility and how that, in fact, could, interfere with the investigations. But by and large, we are developing a social media policy for officers so that we could have consequences if officers, in fact, breach that policy.
I have also seen live broadcasts on both television and social media from crime scenes where police officers are entering a dwelling, for example, to search for narcotics, and it is broadcast live by external parties on Facebook, and the footage is also available on programs on television. How has the police identified this as an issue, and is it being dealt with?
That issue has been discussed, but at present, it is still ongoing discussions, because in fact, the footage sometimes come from various sources, including the occupiers, the residents, and persons in the vicinity. So the whole issue as to where the footage originates from, investigations will have to be conducted to ensure that it has not been, will at least come from the police, but footage or video recordings, various, they are emanating from various sources, and in so doing, the sometimes it's a bit difficult and it warrants extensive investigations.
So I'm referring specifically to these. I've seen live broadcasts on Facebook, for example, Facebook Online. I've seen live broadcasts from crime scenes. So the police are about to enter a dwelling, and that is being broadcast, not by the police, but external parties with links to television broadcasts. And so the public, so you're able to see police entering a dwelling, with occupants of the dwelling coming out, being placed under arrest, being searched, and is that something that is consistent with the law, consistent with the operations of the TTPS, and is it something that the TTPS is looking at?
We have taken note of that, but sometimes information or intelligence or evidence emanate from different sources, including TV hosts and a number of persons. And sometimes when they contact us, they are already in place, and they do their own. They take their own video recordings and footage as far as practicable, but in some instances that occur. But we also believe that there may be some issues with respect to occasionally there may be notifying persons. We believe that exists too, so, but it is something that we continue to speak about, but we are not, certainly it is a policy that we ought not to contact or do anything that would interfere with the police investigations, to ensure that the police investigation is done in a professional manner.
Barbera?
Thank you. I just wanted to clarify in my own mind. You talked about closed circuit television. What in the police mind does that mean? And again, I'm very concerned about the integrity of the footage that is used. So is it that the CCTV cameras used by the police, say for example at traffic lights and other places, there's something embedded in the system that would show that it is a continuous loop, that it has not been tampered with, photoshopped, there are no gaps in the time frame? And how does that differentiate to, say, private citizens' closed circuit TV?
No, let me tell you, I'm not a technology expert. And certainly it would need some more information for me to speak to that. But what I would tell you is that with respect to the national CCTV system, these recordings are done automatically, and it is staffed by persons who are vetted, and certainly those records are put on file and they are backed up. So whatever records we get from the system is actually records that they would have retrieved, and that would have been stored there.
Member Hussain?
I just want to go into some of the clauses of the bill, Chair, if you may permit me. We spent some time on the video recordings. Now, you all would have submitted comments with respect to the identification procedure. Now, the bill contemplates several methods of identification. At clause 12E, page 14 of the bill, identification by video medium, by identification parade, public place with consent, public place without consent, and by confrontation. Now, one of the new additions is the identification using video medium and the recording of the entire identification parade, and I could see the merit in this so that you would reduce the amount of challenges in court with respect to the entire procedure. My question is that you all, as the police service, will have to operationalize this particular piece of legislation. How many police stations or how many facilities does the police service have at its disposal with respect to videotaping of identification parades and also confessions and admissions?
With respect to videotaping of identification parades, we do not have any such facility. But we do have facilities with the one-way mirror, and we have audio recording, but not video recording. So that is some logistics and some equipment that we would have to install. We do have audio recording, but we do not have video recording.
And how many of these police stations have the one-way mirror?
We have, within each police division, and we have 9 divisions, at least, to the best of my knowledge, 1 station within each police division. There may be, in 1 or 2 divisions, there may be at least 2, but at least in the 9 divisions, there are at least 1.
Now, under the Original Evidence Act, it's contemplated that statements given by witnesses can in fact be recorded through audiovisual means. Has that been a practice of the TTPS when investigating crimes?
Well, yes, we have in fact commenced that practice, and especially in the serious matters, homicides, and also all other, some very serious crimes, be it kidnapping and a number of these type of matters, even narcotic matters and so on, and anti-corruption type matters. But we are still have to do quite a considerable amount of training. So we have started training our specialized staff with respect to the serious investigations. And so we need to, we have a plan in mind to continue rolling it out, because we need to ensure that every police officer is trained to use the equipment, and that the equipment, he would be very familiar. However, even like under the Children's Act, we need to have, with respect to video recording interviews with respect to children, there is some need for certification there too, and even officers within the Child Protection Unit, we are also currently engaging that they are recertified to ensure that those interviews are conducted through the video recording means.
Are there any issues from your practice of video recording that you think us as a committee could amend or include in this particular piece of legislation to assist the TTPS?
Well, certainly, one of the main issues that we suffer with respect to video recording of suspects' interviews is with respect to, it conflicts with the judge's rules, whereby the judge's rules said that when we are interviewing a person under caution, we should take it down in writing. And when we video record the interviews, we have to ask the questions as well as write them down and write down the answers, because the law did not provide for just the video recording of the interview of the suspect. They say that it must be taken down in writing. So that is a little concern, although we saw here that it did speak about or being recorded in the law now, interviews with respect to suspects could be recorded. So that would certainly assist us in some way, but we still, according to the judge's rules, we need to have the judge's rules amended to ensure that it also includes that the interviews could be recorded, because one of the concerns we have too is because a number of the suspects that we interview, you would well understand that they speak broken language, and we need to have that dictionary So we are working closely with the judiciary as well as some providers to ensure that we develop and that we acquire the appropriate system to help us with respect to the video recording. And at the same point in time, according to the Evidence Act, we also have to produce transcripts or give a written record of the interview. So we need to see how that would, we need to ensure that we have the equipment that would provide that written record too.
Okay. DCP Philip, you've brought us straight to your written submission, and we've received it, and I believe we've all read it or at least perused it. I believe you have identified about 10 areas there in your submission, including the one you have already raised, which is the potential conflict between the bill and the judge's rules. I see you have devoted a significant part of your submission on this issue of drawing adverse inferences from silence, and you've also identified some practical aspects of the bill that you would like to see changes being made. So I now want to invite your team to take us through your written submission, and on the basis of what you say, we would ask some further questions. But I don't know if Member Vieira wants to ask something before we move on to the written submission. Thank you.
Well, the judge's rules are really rules of practice. This evidence bill, when it becomes law, will be rules of law. And so my understanding is that you can still always have written transcripts as an aid, but once this law becomes law, your audio, visual, and your audio recordings are documents that are admissible. So that should be a big help to the police service. My question really is, how many stations are equipped with this audio recording technology? Well, you talked about training. If you could tell me a little bit about the training, and I would also like to know about the chain of custody from the recordings where they're stored until they find their way to the court.
Before you answer, DCP Philip, I just want to welcome the Honorable Attorney General who has joined us from another meeting. Attorney General, welcome, and you can proceed, DCP Philip.
Yes. Well, let me just apologize for the late submission of the submissions in the first instance. With respect to the question raised by the Honorable Senator Vera, we have audiovisual recording in at least about 17 locations, in about 17 locations in the police service. So
I believe it's 21. I have a list of all of them.
well, I stand corrected, but
We can provide that listing to the
Yes,
committee.
okay.
We have the locations and addresses of all of the suites. I know, sorry, forgive me for interrupting, DCP. I know it's unfair because I know you juggle so much that you may not have had the precise listing. I requested that listing from the TTPS and received it in writing. So what I'll do is I'll undertake to provide that in cross-reference to your team as well.
and I actually made a request, this morning just to get it finalized. So it's probably on my phone there, but I didn't have the time to look for it. But I know that we do have, some. So I stand corrected with 21. So we do have video recording equipment at locations. With respect to the training, well, what we had is that the company that would have provided the equipment would have also been responsible for doing the training. They would have done some the trainers. We would have, in fact, as I mentioned earlier, several members from across the TTPS, in particular those from the specialist units, were in fact trained to do the interviews, to video record interviews. But we do have there is an issue that we are dealing with. I don't want to elaborate on that here, but that issue is an issue that has not allowed us to fully, utilize the equipment, but it is something that our information technology manager is assisting us with. We do have, in particular, need to ensure that we have large quantities of disk to ensure to record these, to keep records and to ensure that we make working copies. So what we do is when we record the interviews, we have a master copy and we have working copies. And the master copy is kept, well, at present by the investigator, and certainly the working copies are what they would use under normal circumstances. So that is, in terms of the chain of custody, is usually kept by the investigator, the person who the person who in fact did the interview, and in most circumstances is the investigator.
Could I just join the Honorable DCP? I can tell you, Senator Vieira, that when we came into office, we discovered that the vast majority of suites were not accounted for. We then went on an exercise of identifying every single suite in every single location, because we confirmed that the judiciary had also been trained in detail in relation to the recordings and the management, because obviously there's a migration of evidence from the TTPS through the prosecutorial arms, TTPS and DPP, and then into the judiciary. It turns out that there had been years of training in relation to the systems, but there wasn't one repository management system. The exercise that is afoot right now between the judiciary, the office of the DPP, and the TTPS is a harmonization exercise. We are in the middle of, and very close to the end, of harmonizing the FTR. That is the entire recording systems and structures at the judiciary, at the TTPS, and at the DPP's office, because the system that is being used, which was the backbone of which came from the Chief Justice and the government of Nigeria, as then modified by the government of Spain, and then the local IT aspects of the judiciary. That platform, which is built upon something called TTGIM, that TTGIM platform has a desktop dial that tells you what is required, who is responsible for dealing with it, what are steps outstanding, where it migrates to. And then the harmonization of the system right now is the effort that's going on. Fortunately, IT Attorney General is the mind and spoke around all of these divisions, because the AG's office is responsible for 19 respective individuals, meaning judiciary, other aspects of it, DPP, etc. You'll remember that we did the criminal division bill, and in that we introduced the prospect for the first time in law of the TTPS actually prosecuting in law. Before that, we had police prosecutors who were not lawyers and who were prosecuting. So we've dealt with a lot of the anomalies. What this is intended to do is to harmonize one consistent practice, and then it has to be applied upon a structure. What I'm basically saying in short is that the structure is being built while we're discussing this. The intention is to have operationalization in full form this year, particularly because we intend to abolish preliminary inquiries this year, which is why this Parliament has been identified as the place for civil courts, giving us 65 criminal courts at the Hall of Justice. But while that system is being built, just as we have in the Privy Council, where transcript evidence are in fact audio and visual, because they are now documents as you've carefully described, you'll notice in the Privy Council, you no longer get written transcripts, you get the video. And you look for the time marker, 1 hour and 3 minutes and 42 seconds. So that kind of migration away from a paper-based bottleneck is what this bill is intended to achieve, whilst we're building the system at the same time. So there's a lot of operational work that is very far ahead at the same time.
I'm heartened to hear that. I'm still thinking about the chain of custody, and I was wondering if you're going to have a central repository.
Yes, there will be.
Maybe that would be the place for the master, and everybody else would have the working until.
So without letting the cat out the bag, there is a national prosecution bill that will be brought to Parliament. In that national prosecution bill, the TTPS and the DPP's office centralize their management position. The TTPS has been operating to its most incredible credit without adequate resources in structuring. There's no one building for the mind and management of the TTPS prosecutorial team. They're spread across the country. The computerization effort in the TTPS, whilst they have resources, it's not been harmonized. So the Commissioner of Police has taken lead on these resources with the urgings of the AG's office, obviously, because we've done the DPP and the judiciary at the same time. So we don't want to use one system in one place and then have an incongruity of systems. So what we're doing right now is we're marrying the systems on a very accelerated time frame basis. And I'd like to compliment the TTPS IT division and the judiciary, because a lot of this is just homegrown IT that is being applied.
Thank you very much, Honorable AG. ACP Philip, you are now invited to take us through your submissions.
Mr. Chair, if I could indicate, and to honorable members, we have received, we at the AG's office received commentary coming from the TTPS in several iterations. In the many years of consultation on the evidence law. Secondly, when we sat and we drafted the legislation. Thirdly, after we first piloted the bill in the Senate and went through the 2 days, we received further submissions. A lot of the observations made in this legislation we have already accepted or have responses to. And Mr. Chairman, I'm going to indicate to your committee after, mind you, I'm not a member of the committee, I'm a minister attending by virtue of portfolio. There's a matrix of suggestions that we've already accepted, some of which are addressed in these submissions here. Had we gone to the committee stage, all of this would have been dealt with there, but we thought it appropriate to refer it to a joint select committee. So just to indicate that we have, at the AG's office, looked at a number of these submissions already and have positions for the committee's consideration in short course.
Thank you. ACP Philip.
Sorry. Having heard the Honorable Attorney General, I should probably go directly to the last submission under Division 3 that I do not, it may be new, it may not be so new, but it speaks to the whole aspect of adverse inferences. I think this is 2019, and the evidence bill is being amended. And we need to, as we continue to level the playing field, in particular for the accused and the defendants, we need to level the playing field for the victims also. So with that in mind, it is timely that the Honorable Attorney General should give serious consideration to the whole aspect of adverse inferences, because while we recognize the whole aspect of the right to silence and the presumption of innocence, as well as that privilege against self-incrimination, historically, what we have observed is that when we interview suspects, they have nothing to say, and they wait until the trial continues, and at the end of the trial, they come up with this glorified defense after having heard all the evidence. So, in fairness to the honest accused persons and defendants, it would be grateful if at the first instance, the first interaction with the police, they make a clear indication as to what in fact, they would want to say in their defense. so that credibility and all the good things will happen early. And it has been so. This is the law in England, and I know that we in particular we use it as good precedent, and they have had this more than 20-something years ago. So we are almost 30 years behind. So it would be good if serious consideration is put in law with respect to adverse inferences by suspects and in particular defendants and accused.
Honorable AG.
Mr. Chair, I couldn't help but smile for the entire submission of DCP Phillips because he has hit the nail on the head. I'd like to just say to the committee, for the benefit of the committee, under the anti-terrorism laws of the United Kingdom, the adverse inference on silence is a very powerful tool that they use in respect of their convictions. Also, post-PACE reform, the UK introduced the adverse inference silence aspects. This has actually come across the office of the AG most recently in the fulminations around the Sedition Act. We've heard in the public domain the allegation that sedition legislation can be replaced because there are laws which are adequately in place to adequately address the situation, when the truth is that the comparator jurisdictions that are being used all have the adverse inference on silence rule. So the United Kingdom, for instance, where we heard recent submissions saying, let's abolish TNT sedition law. There are adequate laws. That was the debate that came up in the United Kingdom and Australia and Canada and the United States, all of whom, every single one of whom, have the adverse inference rule. I would welcome this suggestion. The reason that we at the AG's office didn't volunteer it is that we felt that we would have a ring-down fight over it that may have delayed the passage of the bill. However, the real voice inside of this is the opposition's, because they are the ones that make the submission that our laws are in pari materia, when in fact this is the crux of the law that exists in the other jurisdictions and does not find itself in Trinidad and Tobago. So I would welcome the committee's fulmination and support for this.
Well, AG, I would be one of those that might have a little concern about the adverse inference on silence. I think that is certainly something that one would want to give very careful consideration of, because there are all kinds of reasons why an accused person might be silent at that time. I would point out, however, with your very pertinent concern about an accused listening to hear the prosecution unveil their case and then coming up with defenses, that has been pretty much addressed now with the new criminal proceeding rules and the recent practice direction that was issued by the judiciary on the need for filing a defense statement. My suspicion is that that has not been applied as it should be in practice sufficiently, but it would address the concern you have raised.
Okay. With respect to the adverse inferences, in order for this to properly work, the police service and the DPP's office must be equipped in order to give early and full disclosure, full and frank disclosure. You can't ask an accused person to state what your case is if he doesn't know what the case against him is. That is a concern that we have to take into consideration. I also want to agree with Senator Vieira with respect to the defense stating their case at an early stage in the proceedings, at the stage of case management. Further, this was tested in the Privy Council, and it was found that it's to be constitutional, and we have it in our law. But again, it all goes back to the applicability of this and how it's going to work. So while adverse inference is going to be a wide debate, AG made reference to the Sedition Act, it must be used in such a responsible manner in which you also have to protect the right of the accused, the three rights, the right to silence, the right to against incrimination, and also the right to be presumed innocent. Because we can't force the hand of a defendant, especially in a case of a capital charge, to state what their case is at a very early stage until they have full and frank disclosure. So I don't think at this time we have enough before us in order to make a solid decision with respect to whether or not this committee can go forward with this suggestion made by the TTPS.
Mr. Chair, could I say that I think Senator Hussain has summarized this thing in the most precise form possible. I compliment him. It's the exact point of view. It's why the AG's office didn't introduce it. We believe in the AG's philosophy of just start, that we have to work our way into success, which is why we just started the civil proceedings rules. We just started the amendment of the civil proceedings rules. We just started the application of the rules. The TTPS can testify that they have received from the Chief Magistrate very strict directions on the operationality of the criminal proceedings rules, to the point where cases will be thrown out if they are not ready on time. So the rules are now beginning to grind into the system. I really drew the point to say, and forgive me, I was being a little naughty in provoking my colleague, my dear colleague, Senator Hussain, into saying that one can't simply just roll up and say, repeal X, and when truthfully, the system is not ready for repeal X in its form. But, lay that aside. I think it's a large issue that we ought to track. It came up, Senator Hussain was a member of the Joint Select Committee on the Anti-Terrorism Laws, where we raised the same issue of that coming ahead. And I think that the time for this is a little bit later down the line as we begin to grind disclosure into mandatory aspects and as we define what sanctions for non-compliance with the rules are, because it's a very gray area right now. Obviously, the concept of sanctions can't work if the system wasn't working, which is why we focused on systemic reform first. Plant and machinery, people and processes. Once we got that into place, you plug in the laws and then we work our way forward. But I want to compliment the TTPS on having the foresight onto this particular point. I am very anxious about it, but I share Senator Hussain's concerns too as well, and Senator Vera's. But just to mark the spot that we at the AG's office did think about this in deep form, but we didn't bring it forward for the very eloquent reasons put forward by Senator Vera and Senator Hussain.
Thank you, Honorable AG. Now, I see the Assistant Superintendent, Kerwin Francis, is at the ready to go. Now, much of your written submission outside of the issue of adverse inferences covers the ID parade aspects and the changes which are proposed. And at the opening, I made the comment that this issue of witness anonymity is new, and as expected, there are different views in the Parliament and outside the Parliament. In fact, my colleague member Hussain, in his contribution on the bill, raised about 15 issues, including this issue of witness anonymity. Now, if there was ever I'm just following submissions and conversations from the Trinidad and Tobago Police Service. If there was ever an advocate for stronger protection for witnesses in our current and operating environment, it was the police service. What are your views on that aspect of the bill, which seeks to introduce, in certain circumstances, sanctioned by the court, witness anonymity?
Chair, with respect to witness anonymity, this is a provision that the TTPS fully endorses on two fronts. One, on the side of civilian witnesses who may come forward to give evidence that the state is seeking to rely on in a criminal trial or criminal proceedings, and on the other front, where you have police officers involved in criminal investigations whose identity we may seek or want to protect, given the nature of the investigation they have been involved in. We understand and appreciate that any accused has a right to a fair trial, and that has to be balanced against the provisions which we are seeking to have put into law. And we acknowledge as well the high threshold set by the bill, which requires three conditionalities which must be met by the state, more so the police, through the DPP's office, in having the court consider any application for witness anonymity. from a practical standpoint, with respect to, for example, drug trafficking investigations, many times we have drug seizures, and because of the way drug trafficking occurs, you may have drugs being sent through a courier service, through cargo, where civilians are employed. And the practice, the experience has been that persons generally are fearful to even go on record to say what occurred, even in the performance of their functions when they were dealing with the individual. Further to that, with respect to even attending an identification parade, because of the fear that is attached to drug trafficking, these individuals themselves on many occasions have declined to even attend an identification parade. So with that in mind, such a provision would aid the police service greatly in getting cooperating witnesses to come forward. Further to that, it would not be the first port of call for the police service, because in looking at the provisions of the bill, it contemplates as well having exhausted all other means that are available to the police to bring this witness safely to the court to give their evidence. So those particular areas that are available must have been explored. There must be evidence in support of those areas, and then now the police service can seek to satisfy all three requirements under the bill, coming forward with its application to the DPP's office for such an order.
Assistant Superintendent Francis, for members and members of the public following, because it's an issue that the public would have a very keen interest in. From a practical point of view, is it contemplated, or how practical is it? What are we seeking to do to protect the identity of the witness at the trial, or from the first interaction? Because of course, from a practical sense, a potential witness is identified. If the witness gives a statement, it would have to be disclosed in advance to the defense, so the identity of the person is known, what the person looks like. So how does it work from a practical point of view? Where does the protection, or where does the anonymity begin in the implementation of this provision?
From a practical standpoint, we would want anonymity to begin from the onset of the investigation. In that way, the witness himself or herself is afforded that safeguard, knowing, look, there's this order in place that prevents disclosure of your identity to any individual who may be seeking information surrounding the investigation, and by extension, any witnesses who may be involved in the investigation. So that is the first level of protection we would like to see. I've seen that reflected in the UK. Further to that, the second tier now would be when criminal proceedings are instituted, where the witness now is afforded that protection by way of their identity being withheld at trial in the courts. So 2 tiers of protection during the course of the investigation, and then at trial to its completion.
Member Hussain.
Thank you very much. Chair, through you, to the members present. Under the Evidence Act, at Section 15C, and in particular 1E and F, it states that statements can be admissible where a person is kept away from proceedings by threats of bodily harm, and no reasonable steps can be taken to protect the person, or is fearful and no reasonable steps can be taken to protect the person or others, or to protect him or others from financial loss. So you would agree with me that already in the existing law, there are provisions to deal with witnesses who may be vulnerable to threats from the elements. This provision that the bill seeks to include is an order where the witness himself attends the court and gives the evidence under circumstances of screening, or through video link in an unknown location. Wouldn't you agree that the clause or the provision that already exists in law protects the witness even more? Because in this instance, the witness does not even need to come to court. The statement of the witness can in fact be tendered as a hearsay statement, and it will be read to the jury. However, the only difference is that the defense will not have an opportunity to cross-examine the record maker of the statement. However, in this instance, the defense now has the opportunity to cross that person. So that's one issue I'm raising. The second is that if this provision already exists in law, then how do you treat with those witnesses who are fearful already? Because one of the submissions you made is that you want protection from beginning to end. But it already exists that persons may have been fearful at the time of giving a statement, at the beginning, and then to the end of the trial. So how do you deal with those circumstances of witnesses who are in need of protection?
With respect to the provisions under the Evidence Act, yes, it allows for the statement of the witness to go in. However, as you rightly indicated, Senator, the defense does not have an opportunity to cross-examine the maker of the statement. With this provision, he's afforded that opportunity. So to me, from the TTPS perspective, it gives the defense a greater opportunity to cross-examine a witness, albeit that the identity of the witness is not disclosed, and in our view, assist that accused or defendant in the court, as opposed to the provisions that exist right now where you just have the statement being tendered and there's no opportunity to cross-examine. So it adds a level of fairness, or a greater level of fairness to a defendant or accused.
But we could moot on that point, because at the end of the day, when the statement is disclosed, you will know who the witness is, you will know...
Mr. Chair, sorry, just to jump in, forgive me, Senator, if with your permission. I think Senator Hussein's question is, or rather, line of inquiry is spot on to a point. Senator, forgive me, ACP Francis has raised a question of when the order applies. I just want to refer to what the law proposes in the bill. So at 12 AG Alpha Golf, where there are reasonable grounds to believe that the identity of a witness should be concealed from an accused person and the public so as to protect the witness, any of his relatives or any other persons, the court may grant a witness anonymity order. A party to criminal proceedings may, in relation to a witness, make an application. So I want to ground the suggestion here now as to whether this ought to be moved beyond the ambit of that pot. That pot right now is criminal proceedings. Where one defines a criminal proceeding to begin is the key point inside of here. Are we to disaggregate the events prior from the events post? I would think that arguably, insofar as disclosure only comes about when proceedings begin, I think we're safe. Because insofar as that's the case, 12 AG contemplates that anybody at that point, for instance, under the criminal proceedings rules where you are giving disclosure for the first time, as you must, you can make the application for a witness anonymity order. But there is nothing in this law that prevents conditionalities from the order, such that the court can revisit the failure to disclose the position. So it is contemplated that rules and regulations will be made under these positions. Because as drafted, certainly as I intended in scrubbing this draft, it was intended to come from when proceedings begin, because that's the point where disclosure must happen. So anywhere along the point of proceedings beginning, the intention of the drafter of the law was that you could knock on the door of the court, say to the court, I'd like you to consider the grant of a witness anonymity order. It was in my mind that the court would, in its full discretion, because this is entirely up to the court, that the court would say order granted or refused, right of appeal may exist or not, and then conditionalities can apply for the revisiting of the order. And that is where you then get into the position of whether one attends personally or is deemed to attend and you're not dealing with a hearsay admission of a statement, which is put that way. So I think that we're actually on the same page, but I'm speaking now as the drafter of the law, what we intended. We intended proceedings begin, disclosure arises. Obligation of disclosure is currently managed, A, as a matter of common law, statute, and criminal proceedings rules. At that point and any point there, the party to the proceedings who wishes to use the witness anonymity order can apply to the court for consideration. The court then may or may not grant the order, subject to conditions as it may see fit. And what we can do is we can scrub that down into any regulations or rules that may be required to make that operate, just for the record.
What is the submission of the AG is. Now, it's settled law that what forms part of the disclosure to the defense would be the credibility of the prosecution's witness in terms of disclosing their criminal record, because that forms part of the cross-examination of the defense when testing the evidence or the veracity of the statements given by the witness. Now, if an order is made in this circumstance of anonymity, how is it that now the criminal record of that witness forms part of disclosure? Is it going to be a redacted version? Because at the end of the day, the jury must know whether or not this is a witness of truth.
So it's settled law that you must disclose the case that is least favorable to the prosecution to the defendant. In other words, then, you must disclose the worst version of your case to the defendant. That may and does include some of the aspects of the character of the person. There are rules of bad character. There are other positions that no doubt come about. But when we look to the Star Chamber and the European decisions that come out of that, and as they have tiered the analysis of this thing, the weight of the evidence of witness anonymity orders have been in sharp focus, and more particularly, the conviction on the basis of a sole witness, in particular witness who is anonymous, those have been frowned upon in very serious points, to the point where the courts, the Star Chamber in particular, has said unanimously that if you're going to convict on the basis of a witness who is anonymous, don't do it, for the very reasons of the fairness of trial and other aspects. So the case law is very persuasively in strength, pushing at the point that the caution is to be given to the balance is to be shifted to the accused if you're going to rely upon the strength of an anonymous witness position. But this has been well articulated in the jurisprudence, both in the United Kingdom and in the European Star Chamber as well.
Vera?
Chair. As a matter of practicality, I would expect that in the course of an investigation, you would keep the witness's identity anonymous. It only really begins to become relevant when you need to seek an order, when proceedings have actually begun, and then the disclosure requirements kick in. But I was heartened by you indicating that the police are aware of the seriousness of witness anonymity orders, that you would exhaust all measures first before seeking to go down that route. Because I take the view that those orders should be used with extreme caution. And in the few situations where they are absolutely imperative. Having said that, I would like to get from your own experience, based on what you've encountered. There's a difference between being fearful because I'm afraid to talk in public and go to court, or I'm afraid to take time off from my boss's work, and being in real apprehension of loss of limb or life. So the grounds to believe is what I'm coming about. And in your experience, can you tell me about witnesses who've been threatened, about witnesses who may have been harmed, about witnesses who've been assassinated, so as to justify the bringing into law these provisions?
I just want to go back to one point the AG makes, and then I'll come to you, member. Honorable AG, with respect to the current position in the bill with respect to the order where it's applied for only at the institution of the criminal proceedings, in our submission, it was intended that further leave would have been asked for through the chairman to make further submissions to include that provision of getting that order from the beginning of an investigation for the consideration of the committee and your good officer.
Mr. Chair, I don't think that there's anything that could stop that submission coming, and then the committee could consider, if you've got precedent positions, etc. That whole consideration, I think, is something that the committee could look at. But as drafted from the policy position from the government, we erred at the beginning of proceedings because we were fearful of the Gestapo approach of, sequestered information and, how that can go. Again, not that it is not a very worthy submission. This is a very far-reaching and progressive view that the TTPS has recommended. The question is if we are societally ready for that just yet in terms of our progression through birthing a criminal practice, which is now much quicker than before.
Okay, PCP Philip, so.
Sorry, Mr. Chair, it might be, Senator Vera just said something which was so powerful. It might be that we want to convert some of the tipping off provisions to other aspects. Because tipping off is a massively important venture. And the tipping off really gets to two sources of difficulty: a person and a law enforcement officer. So Section 51 of POCA is a powerful piece of law when considered in the money laundering context. The question is whether we consider money laundering to be more serious than rape or murder or grievous assault. So is it time now to put in this Evidence Act a tipping off provision, particularly as the TTPS is reforming itself right now, and you're going into more and more stringent analysis of what the Americans call who's in the room, who's approved to be in the room, and who can be certified to continuously be representing the truth in the room. So maybe it is that we could look at it in that context there.
Thank you. CCP Philip, I want you to take us through and help us get a practical understanding, and the public in particular, of, I know you support these changes, subject to some of the suggestions you've made, but you do in fact support changes to the way ID parades are conducted and statements are taken and so on. So from a practical point of view, based on your written submissions, can you take us through what you are recommending, and
Yes.
also share with us your views on how this may assist in criminal prosecution?
So, with respect to clause 12, and that has the definitions included. When one look at the definition of identification procedure, we did say means a method or system of ascertaining or determining the identity of a suspect for the purposes of an investigation, and they have as specified in section 12E 1(a)(e). However, there was a concern under 12B, which appeared to be the use of photographs to assist in identifying suspects. While they speak about this as a procedure this is a process prior to the commencement of an identification procedure, there was the belief that even the showing of photographs to a witness is actually part of an identification procedure. So there was a recommendation, or we put instead of prior to, we had as part of the conduct of an identification procedure, we wanted to include that the whole aspect, although that was not mentioned with respect to 12E in terms of both 12E1, both subsection A to E, the whole use of photographs. But we were of the view in the practical sense of the word, of the way we conduct our business, is that when you have a report and you have witnesses present, sometimes the whole use of photographs is in fact triggering some form of identification if somebody, So we were concerned that it may form part of the identification procedure. But just to progress that, we also saw that under 12B4, they said that we had basically here that where a suspect has been positively identified by the eyewitness, the investigating officer shall, in respect of the matter under investigation, take all necessary steps. And we were of the view that even under 12.3, under 12B3 too, where they have the word investigating officer, because that is one of the processes that we should have there, identification officer instead. And in order to ensure that we have some integrity in the system, we do have, there is provision in the Act for the identification officer to in fact delegate, or he could authorize other persons to participate. So we were saying there that the photograph should be shown by, somebody at the rank of corporal or sergeant, just out of integrity, to keep the, as a suggestion. If you, to ensure that the process,
What's the current practice, just for the record?
The current practice
Yeah.
is actually, we would have the investigating officer.
Right, so you want to move away from the current practice, which our standing orders provide, which is the investigating officer shows you the photograph, and now take the caution and say, let a identification officer do that instead.
An identification officer who is authorized that he could delegate it to either a sergeant or corporal.
So
because we wanted to, we were of the view that, is it being considered part of the identification procedure, or is it outside of the identity? We were looking at it, we were viewing at it as it may form part of the identification procedure.
So we defined identification officer as a police officer of the rank of inspector or above,
Yes,
who is not involved in the investigation,
Yes.
and who shall be responsible for identification procedure. Then we have the investigating officer, means a police officer involved in a criminal investigation. In Division 2, when we deal with identification procedures, before identification procedure takes place, etc., record. B, use of photographs. So we've pinpointed here, prior to conduct of identification procedure, an investigating officer may use photographs to assist in establishing the identity of a suspect, but that's prior to the conduct of an identification procedure. Where photographs are used, a minimum of 12 shall be shown to an eyewitness at the time. Then you ensure these things. Detailed record. Subject to 3, identification procedure shall not be conducted unless a suspect is known and available. So I didn't see this, in borrowing this from PACE and from the UK perspective, we took it as, with reasonable certainty, having someone who knew what they were dealing with, preparing. This was travaux préparatoire, preliminary work to get you to the point of then putting it to somebody. So you had to have some reasonable certainty as to who a suspect was. Otherwise, it could be too diffuse. That's the way I understood the English practice and why we thought of it that way.
AG, what I'm seeing is the way the law is being slanted is that you want to preserve the integrity of the identification procedure so that there's nothing to corrupt it or to undermine it. You are free before the identification procedure to show, as says a 12B, prior to the conduct of an investigation, identification procedure, an investigating officer may use photographs to assist in establishing the identity of a suspect. Up until that time, you can show the photographs. But from the time the identification procedure kicks in, then it's off limit.
That's where 12D kicks in. So 12D says, after you do all the preliminary fair certainty aspects, so that there's integrity in ensuring that the right person is potentially in the zone, it's at 12D that we then kick in to say the identification officer shall be responsible for making arrangements, conduct identification, etc. So we borrowed from the English that line of logic, which I thought was there to preserve the integrity and certainty of you've not been on a fishing expedition or just rounds up a set of people unfairly and brought them forward and pinpoint some degree of liability to the investigating officer to make sure that he was not out with the law, particularly as it relates to malicious prosecution, as it tends to come up from time to time from the state's perspective.
Okay.
One comment, please,
Yeah.
Chair. With respect to 12B, practical application, a robbery takes place, victim goes to the police station, makes a report, gives a first description. What TTPS is contemplating is that instead of having the investigating officer present the photographs as pre-work, to maintain the integrity of that whole identification process from the beginning to the end, have it done by some other officer. Not necessarily the identification officer who will be conducting any one of the identification procedures. That is one option. So that is the practical application of what Mr. Phillip is indicating, to add a level of
But
integrity.
what do you currently do? Isn't it currently your practice that the investigating officer would do this right now?
Correct.
Right, so what experience have you had from a prosecutorial failure point of view, a malpros point of view? What mischief are you addressing by recommending a shift from what you do right now and which other laws suggest? In other words then, why change it?
Well, it was basically ensuring that outside of the investigating officer, we have some other ranked person where, in terms of dealing with the whole aspect of photograph identification, handle that matter.
But what I'm asking is, has it come in for condemnation in court? Has the practice at the TTPS said, well, look, there's a problem we have to fix? I'm sort of cautious about changing things too quickly and building on systems that may cause complexity in your investigations. Because wouldn't we, by deviating from the established, age-old, successful route, now be introducing a line that the defense now says, well, you know, let's attack the event prior? See, there's some degree of certainty in saying, well, look, the investigating officer prepared the material for the identification officer to go and do certain things. So I thought that that was a safe practice.
Again, it was a suggestion just to ensure the integrity of the system. That was basically that.
But now I have you on record, forgive me for rejoining, as saying that there may be suspicion as to the integrity. And if there is, I want to know, well, what is it? What has come about? Has the court condemned it? In your practice, do you think it is unsafe? Why should we change it now as a matter of policy?
One of the issues that we were also viewing it is we were considering that it may have been considered to be part of the identification procedure. And since identification procedure spoke about inspector and above, and we do not have enough such inspectors, we were just saying that if it is considered part of that, could we now delegate that to the rank of corporal or sergeant. It's basically within that.
I understand now. Thank you so much.
Thank you very much. The next area in your submission deals with the destruction of photographs.
Yes. We were under 12B7. The consideration was given. We were looking just as in light of the same policy with respect to fingerprints. We were saying that even if someone has not been positively identified, by the eyewitness as the suspect, they said that the photograph should be destroyed. And we are saying, given that the collection of photographs would come from persons who have either been convicted, persons who have been detained by the police, arrested by the police, and so on, we were saying that the photographs should not be destroyed and should be kept for a period of 5 years. Because we would have to be using, it is mandatory to use photographs, so we would need to have
So, Mr. Chair, here's what happened. We recognized in the debate that we were in conflict with the destruction of photographs elsewhere. So we had actually drafted an amendment to cause the destruction of photographs. So we understand, and when I asked my team, I said, where did this come from? They said the TTPS made the recommendation, but then I had to wrestle with the fact that we do destroy photographs of suspects. And when you think about it, when we looked at the DNA bill in particular, and we ran into the Kennedy and Marpa decisions, the destruction of information, in that case, DNA profiles and fingerprints, and obviously photographs run alongside those aspects. You would think that there is a balancing right to be had. So we had recommended for the committee's benefit that we actually go back to the consistency of destruction. I don't know what the committee's view will be on that when it considers it in the round.
Thank you. Your next submission relates to 12E1.
12E1. Yeah. One of the concerns, having read, obviously, the piece and the English law, we did see under 12E1 this parity ranking. Now, one would well imagine that one would have to be able to determine why we didn't follow the parity ranking. And since that we are of the view too that there may be some need for some training in particular, starting at video identification using video medium in accordance with 12G. At present, we normally start with B. So one of the concerns was that we need to build some capacity to deal with A, and whether that in our context could have probably come just, we start with B, B becomes 1, C becomes 2, D becomes 3, and then that the video becomes 4, because we would have to, we certainly, that has not been our history, and we would have to, unless we get some, some date in the future to at least be able to deal with it, because we would always be, I am saying that we certainly would not be able to comply with this immediately if it becomes law, because it has not been the practice. We normally deal with the identification period and so on.
So, Mr. Chair, as the drafter for the benefit of the committee, the reason why we had put A first, which is subject to two conditionalities: A, practicability, and B, the availability or cooperation of the suspect. So we wanted to push the video aspect first because it would encourage a safer form of participation. the psyche that we saw in the policy behind this legislation was that most people were reluctant to participate in the identification parade because there are perhaps untruthful stories outside there about standing up in the room and the light turn on and the one-way mirror, you see the guy and family outside waiting for you and see you coming inside. And with all of those things inside, we had urged the video medium in accordance with 12J first. But we recognize that until that becomes a system that is in full operation, that the practicability argument will excuse A being number one and then take you to B. So if you had not the equipment or you had not the opportunity to operationalize it, that would be your excuse. Practically speaking, you couldn't go for A first, but we wanted to urge the practice this way, particularly because the medium is relatively cheap to be put into effect. It just requires training and consistency. So that was just the rationale behind the government's approach in the ranking of priorities for these positions.
Chair.
Member Vera, followed by Member Hussain.
As the implementer of the procedure, I would be guided by the police, because if they say this is how they feel most comfortable in doing the priority steps, I would take very much on board, their practice. But trying to accommodate your suggestion about raising the bar, my question is it in the foreseeable future that you could see that this be a ranking that you could live with, or you would still prefer for the time being to follow as you have suggested in your recommendations?
It's up to the government to underwrite the facility. We will have to pay for the facilities and cause its implementation. And just to give you the example, nobody wanted the criminal procedure rules. A lot of noise about it. We had 26 years of opposition to the abolition of preliminary inquiries, led by the criminal bar. We then had the criminal division. The Law Association adopted a most inconsistent and egregious inconsistency in saying yes to the FCD, Family and Children Division, where we implemented the exact model for criminal divisions for children. And then they rolled up and said, no, we have concerns constitutionally about the criminal division. And I had to ask them, well, which is it? You're okay with it under 18, it's in operation in the two courts, and now you're coming to say you have concerns about it for over 18? How do you explain that? They then went silent. So we are conscious that when we built out the criminal division, we had to go and underwrite the hiring of 531 people. We had to expand the courts, expand the judiciary, expand the complements, and we did it because otherwise the law couldn't be operationalized. So in this scenario here, we've taken a policy decision that we will have to underwrite and foot the bill for training, for plant, for machinery, for equipment, for the TTPS, because what we saw coming forward as a traditional complaint from the DPP's office is that people did not want to participate in the witness identification parade.
And to add to what the AG is saying, there may be some consolation because it says subject to practicability. So,
Hussain?
Chair, what I want to find out is the practical aspects of the police conducting its work. On average, how long will it take for a suspect to undergo an identification parade from date of being detained? What are some of the obstacles that you all encounter? Because there's complaints that it takes some time. Some may take faster than the other. What are some of the issues that you all have with respect to these identification parades?
Certainly, for an identification parade, and we're talking about the lineup identification parade that we speak about, we need to get persons who closely resemble same age, sex, whatever, as the suspect. That sometimes causes some concerns. The availability of the witnesses causes some concerns. And then sometimes the availability of the attorneys, some of them, they want to witness the parade, or a relative, as the case is. And the odd time too, we do have a number of investigative type issues that comes up, you know. So there's a particular tactical decision as to when to put the person on a parade, because you can't really move around a person. So we have to locate, generally, we have to ensure that a person is located close to a facility, but sometimes we don't have the accommodation in terms of the cell space in the court. So there are a few of those things do sometimes cause us
And
some delay.
Having regard to those issues that you identified, do you think the introduction of identification by video medium will address these issues?
Well, it would, but I'm just saying too that it would take some time for us to build the capacity, because it is new, and we want to ensure. They talk about, in some instances, when you read it, about 9 such, 12 such, you know, where do we get these video footages? This is a small place. I do not know if we have to get some, you know, we have to work out the logistics. And then what is of concern here, when they put this in the following order of priority, you have to go first and say why not, and then, you know, well, you have to give reasons why you didn't use this, and then the person may. So if you put it in a particular location where and given that we are third world and developing, put it in a realistic position, it helps us. It helps us. We want to be realistic. Yes, we do things. There are a number of things that are going on that we want to be first to, like the adverse inferences. We want to be first to that, you know. And in this particular case, we want to be realistic here. We want to be realistic. So we are saying, put it where we won't always have to be excused. Well, we didn't use this because, because from the time you start to give excuses in the court, they start to see incompetence, you know. We'll look at them again. So we are saying we need to build the capacity. And I am just saying that we will do our best, but the reality is that we should put it in a realistic position where we could, in fact, get it right.
So, Mr. Chair, if I could just join in. I understand the position. Having had a small bit of experience, certainly not as long as many people in the room, in getting executives to support the institutional reform of entities, one thing that I've realized is unless I create a rationale in law to compel change, which compels the expenditure, which compels the institutionalizing of change, it doesn't happen. So when I put it in law, and the fact that we constantly have to complain, it's not anything other than the judiciary reminding, and then that forms the basis for the TTPS saying, hey, we have to do this. The courts are criticizing us. You'd note today in the Newsday, quite an incredible publication about the state of our prisons. Nobody who turned up at that event, well, first of all, we denounced that convention when the hanging for Dolce happened. So we're not members of that conventional body. But none of the persons that attended there bothered to say, well, whilst these are the problems, Trinidad and Tobago reestablished a whole new matrix which is in effect. New court structures, criminal proceedings, data analysis, all the work that has happened in the last couple of years has really been the equivalent of about 26 years work crunched into one. So that only happened because we set the bar differently and caused the expenditure to happen. So we feel confident that we need to constantly urge any government, because governments come and go. We wanted to establish a bar that the court would constantly say you have to achieve and cause the reform of the systems that way. Because what we found out is that the availability of witnesses is what cripples hard police work. We just can't convert intelligence, good information, potential evidence to conviction because it collapses at the point of witnesses. And this bill, the guts of this bill, is defined to try and capture the witness integrity. And one of the prevailing fears in this country is witness security and ease of management. So that's why we have, from a policy point of view, ranked the priority A over B. Because if we put B, then we would have no compelling reason to change the situation. We wouldn't be constantly explaining because we just go with what we know. And what we know right now, not working.
Viera?
And just, again, if it will give you comfort, because, I mean, you've expressed quite strongly, you know, your position and your concerns, but 12E2 makes clear, notwithstanding the order of priority established under subsection 1, where it is impractical or circumstances are unsuitable to conduct an identification procedure in the order of priority, the identification officer shall offer the next identification procedure in the order of priority, which is reasonably practicable in the circumstances. So there is some give. I very much take on board what you've said, but that should give you some comfort.
Thank you very much. In your next two submissions, DCP Philip, 12F1B, you have raised the issue of inconsistency between what is proposed, and that deals with the protection against self-incrimination, the inconsistency with what is proposed and the judge's rules. I think Senator Vieira has responded. And is there anything more you want to add?
Well, Senator Verrill's response seemed to be saying that what we put into the law would alter the judge's rules. But I was looking at consistency because in terms of how the judge's rules, the wording of the judge's rules, and in the same breath, since he did speak about rules and law, and I just want to go back to that in a little bit. We spoke about the criminal procedure rules and the whole aspect of the defense, you know, to give us the defense statement and those rules. And if we put the adverse inferences in the law, that as it is in the English legislation, it would be even more powerful than the rules. So what I'm saying here too is, this change here in the law, is it to say that inherently the judge's rules, the caution has now changed?
What I'm saying is that this is the law, and this will trump practice. Now, the other thing I want to say is, when you read this section that you've identified, I think it's even more elegant than what is customarily said in the rules, because the caution under the rules is, you are not obliged to say anything unless you wish to, but what you say may be put into writing and given in evidence. Now compare that to this.
And may be given in evidence.
Yes, no, and given in evidence. What this says now is, you're not obliged to say anything unless he wishes to do so, and that anything he says may be put into writing or otherwise recorded and may be given in evidence. It's not far apart, but I think it actually improves what you have been accustomed to.
Subject to, to disagreement. But
we take note of
it,
the
yes,
submission.
Yes,
The next submission relates to clause 12L. I myself have read the clause and I've read your submission, and I think we'll all benefit from an explanation from you, from a practical point of view, of what you want to achieve by the change you've recommended.
The change that we are recommending is that you may have an identification parade, and the witness may have identified the suspect physically. And then there's a request by the witness to speak or turn or whatever. And then one person on the parade, and I'm specifically referring to the suspect because they are well briefed by the attorney and so on, they do not comply with the instructions of the identification parade officer. And then we have to abort that. Now, there's a lot of time and effort in that situation because, they are very, they are very, for want of a better words, they're tricky. So at the end of the day, it would just help to frustrate the parade. So we believe that the parade should not be aborted. in light of persons either didn't speak or, and especially if you have already been physically identified, because the reality of identification parade is to identify you in the physical sense. Yes, the different, if somebody is asked to say something or to turn or to walk, that is some additional, but we do not want to ensure after we would have gone through that process and one person, mainly the suspect, failed to comply, that the parade is aborted. Because he's the person more than likely stands to be, a decision has to be made on him. So if he realizes he's already identified and then there's the possibility now of a further request and he doesn't comply and the parade is aborted, we may not be able to use the result of the identification parade.
Thank you very much. Any member has any response on that particular submission? No? The last area, DCP Philip, relates to the approved forms, and it is a submission made by my colleague, Member Hussein, during the debate. So we have taken note of that submission, which is essentially to have the approved forms included.
In the schedule.
And it's a matter that the AG would look at. As we close, I want to ask you first if there is any other submission or anything you would like to say to the committee and to members of the public in relation to this bill.
Officer Prague would want to say something.
Yeah, morning, each and everyone. Morning, Mr. Minister. Division 3, interviews and oral submissions, 12R. The Commissioner of Police shall cause to be established and maintained at each police station a register to be known as the Register of Interviews. And there are 4 points that you have, A to D. We would just like to see E, where it shall be included in the register any other person present during the interview. Because most times there's a senior officer also present while the interview is going on. So in addition to your 4 points, we just want that additional point to be included. I just wanted to address Senator Hussein on one of the challenges that we face with respect to the identification period.
Sure.
Is the issue of remuneration and incentives of participants. Yes, we have a small fund, a police fund, where we give participants for attending the identification period, but we want something in the law saying that the incentive will come from a special fund, because when you go to get participants to come forward, they refuse, saying, what's there for me? Why do I have to come in a lineup? So instead of the fund coming from the police fund, let's have something given in law under the government.
Well, I remember when we were little boys growing up, people look forward to getting some rum and cigarettes. Was that rumor or was that true?
That is real.
Real.
Yeah, at that time, it's no longer that.
And now okay.
Question,
So,
when you say not coming from the police fund, you mean not coming from the appropriations given to the police?
Yes, to that extent, yes.
Right, so just as I understand appropriations, so the TTPS is one of the largest receivers of appropriations across all entities in Trinidad and Tobago. If we were to put it from a fund that comes outside of the government, outside of the TTPS, they all come from the same pot, is the Minister of Finance to give. So as I understand it, all that is required is a line item in the TTPS budget where you know that that's the pot of money. I'd be loath to recommend going outside the TTPS because of Section 123A of the Constitution. I wouldn't want any entity to frustrate police business when the law as it currently is that the TTPS has its own authority to manage itself any way it wants to. So once that line item was in the budget, they could wire money, they could request supplementation, but I think from a policy point of view, the TTPS should always have its commissioner in charge of its business, and no politician or Minister of Finance or anybody else should ever be an encumbrance to that operation?
Yes, sir. I think while he understands that, probably the whole aspect of the slowness in which funds become available.
Well, boy, if you
But that's
see
another
the
thing.
slowness
Yes, sir.
in requesting it from our ministry.
Let us not get into that.
I get the point.
Yeah.
But what we may need to do, and I take the point Mr. Prague, is to perhaps work on a better operationalization of that, how it can be done in real time, because that seems to be the problem, right?
Yes, sir.
What it is, standardizing it, and then the real-time approach, and making sure it's not abused. Correct?
Certainly, sir.
Got you, Sue. Thanks.
I'm just curious, what is the remuneration that you give to these persons who
I thought
participate
that question might be asked.
on these parades?
My understanding is $60 a piece.
$60?
Yes, no.
Well, you could get some rum and cigarettes for that. Member Vieira had asked
Yes, before,
earlier about witness interference or witness tampering.
I wanted to get a sense of how real, how serious the threat was to justify that provision.
So, member, I do not have any statistics here with me to give you on a case-by-case basis. However, what I can say from investigations that my unit has conducted, the general fear expressed by individuals is fear of harm to themselves, to their families, or damage to property, but more so fear of harm to themselves and their relatives. The fear expressed is not one that deals with time off from work or the concern about being fired by their employer. So that concern is one that is seated in fear of harm to themselves and their relatives.
Would it be possible to get statistics that you may have showing where witnesses have been assassinated, have actually been harmed, trials have been derailed because of intimidation?
Attempts will be made to get those stats and forward them to the Honorable Committee.
But I'd like to just point out something. So it does exist, right? In this year's newspapers alone, I could think of 5 off the bat. That 5 is enough. The mother killed with her son, the outside the graduation, the doubles vendor, you name it. That is enough in the echo of the Fourth Estate to make sure that nobody turns up. It's the same reason why we see those very large numbers in the jury exemptions. Hundreds of people in the court saying, I don't want to be a juror. But I do appreciate the evidence nonetheless.
Gentlemen, I want to thank you for at short notice responding to our invitation and also providing your written submission for, I look around, for most of us on the Select Committee, we need assistance because from a practical point of view, we understand language and law and legislation, we understand policy, but from a practical point of view, members of the public having to interface with the police during an investigation and the police having to conduct its investigation, we appreciate the opportunity to understand the difficulties you face and how these things could improve. We welcome your further submission on any matter, including the data that has been asked for. That is important information, and we know from reading the newspapers and we know from living in Trinidad and Tobago, the issue of witness interference, tampering, threats to witnesses, witnesses being killed, investigations being derailed, we know that, and we'd appreciate the data. And any other submission you want to make on this bill that you believe will assist us in our deliberations before we report back to the Senate. So I want to thank you, DCP Philip, Mr. Prague, Mr. Francis. Thank you for your work as officers of the Trinidad and Tobago Police Service and your work in support of us as legislators and to help the public understand. I want to thank the members of the committee, the Honorable Attorney General, who has been juggling, is always juggling, but has been here with us and has indicated to me that he would try to be as part of many of the meetings as he could. I want to thank the CPC and the Parliament Secretariat. Most importantly, I want to thank viewers and listeners who will follow the rebroadcast later, the broadcast, I should say, later, and would also make submissions or make comments that will assist us. Thank you very much. This meeting is adjourned.